Okay, so Mr. Heiser, you are brought in on a warrant with regard to a balance that you owe from this 2002 case in the amount of $811. The last payment that was received from you was in 2010, amount of $25. You were put on collections. There was a show cause back in 2015, and there was a bench warrant that resulted. You haven't made a payment in more than 13 years. I mentioned it was Judge Power, maybe Judge Rogers, who told you initially that this wasn't going to go away and that you needed to resolve it. Well, here you are.
Right.
Your monthly payments were set at $25, but we typically now, since it's been 13 years, we set them at usually a minimum of $100. Are you working right now, sir?
I just retired, sir.
Okay. And do you have income coming in?
Yes, I do.
Okay. And are you able to afford a payment of $100 a month?
Yes, sir.
Okay. And are you receiving W-2 income or 1099 income, or is it all Social Security, for example?
It's off Social Security.
Okay. No other income other than Social Security?
No, sir.
All right. Well, here's what I'm going to do. What do you have available in your checking account right now?
I have like probably $50 right now, but I will have more in the next couple of days. I just need to get out and I need to collect some money. I just sold one of my race cars. So I will pay, I can pay it all in a matter of a couple of weeks.
Well, that would be good, but here's what we're going to do. I'm going to require that you pay $50 on or before November 1st, and then
Okay.
the first of the month, each month thereafter, the amount of $50 per month until this matter is paid off.
Okay.
As you just found out, you can't ignore it, can't pretend like it doesn't exist. It'll come back to haunt you. You should understand that an order of payment is actually an order of the court, and that is, if you violate, that can be contempt of court, which can be a separate criminal misdemeanor and can put you in jail for up to 93 days and result in a fine of $500. I don't want to do that. I just want you to get this taken care of. So
yes, sir.
let's put you on that plan. $50 a month starting on the 1st of November. If for some reason you can't make a payment, you better call in advance. And if you can get it paid off sooner, that's obviously to your benefit, okay?
Okay, yes, sir. Thank you.
All right, we'll process the paperwork to release you. It should be signed by the end of today, okay?
Okay, thank you, sir.
Take care.
Okay.
Let's go ahead and bring in Mr. Fish, I believe. All right, you're Mr. Fish, is that correct?
That's correct.
All right, sir, we're going to go ahead and put you in a breakout room with the MIDC attorney, Mr. Johnson. Tiara, if you would go ahead and take care of that, please. Okay, Mr. Fish is back with us. Let's go on the record. This is file 23-14658FC. It's the time, date, and place set for an arraignment on a warrant requested by the Grand Traverse County Prosecutor's Office. Court is in Leelanau County, but this is a Grand Traverse County matter. This is a Judge Hamlin matter. I'm handling it on his behalf today. The warrant alleges that the defendant violated his bond by exhibiting positive test results on the 25th and 26th of September. On the 25th, the presumptive positive results were for amphetamine and cocaine, and only amphetamine on the 26th. The defendant is here along with his attorney, Mr. Johnson from the MIDC. We have Mr. Wiles here on behalf of the prosecutor's office, Ms. Henry from the clerk's office. Ms. Daniels doing our court reporting, and we are handling this matter by video conference, absent objection. So, Mr. Fish, You should understand that what has been alleged against you is a violation of your bond. That can be considered to be contempt of court. Contempt of court is a separate criminal misdemeanor. It can result in a sentence of up to 93 days and a fine of up to $500. You'd have all the same rights that you have associated with any other criminal matter, including the right to go to trial, the right to an attorney. If you can't afford one, one would be appointed for you at the public's expense. You'd have the right to have the prosecutor prove your guilt beyond a reasonable doubt. They produce witnesses, documents, exhibits. You'd have the right to cross-examine their witnesses and present your own defense, including any witnesses that you needed. I would order that to happen. At the end of that hearing, Judge Hamlin would again make a determination as to whether the prosecutor had proved their case beyond a reasonable doubt. Now, we can also review this as a bond matter. That's what I'm going to go ahead and do at this time, absent objection. Mr. Johnson, does your client have a position with regard to the charges against him, or is he going to admit responsibility?
Thank you, Your Honor. My client recognizes that he has the right to a hearing to contest these charges and to have Mr. Kane present for that hearing. He would be exercising that right today.
Okay, we'll go ahead and set this matter for hearing. We'll go ahead and notify Mr. Kane of that hearing. And it will be set in front of Judge Hamlin here in the very near future. Let's go ahead and have a conversation regarding bond. Do you have a motion regarding bond, Mr. Johnson?
Thank you, Your Honor. Mr. Fish indicates that this is a first of potential bond violation, so he's been doing well. Otherwise, he is employed. He does also take care of his mother. So we would be asking that bond be permitted in this case with terms that would reflect the probation or the bond terms as well. So obviously testing would be critical, and he understands that he's under a microscope right now. But we would be asking for bond this matter pending the hearing.
Okay, thank you, sir. Mr. Wilds, does the prosecutor have a position regarding bond?
Thank you, Your Honor. It's my understanding right now he's testing 4 times per month randomly. The people would be asking for a more rigorous testing regimen and that he test clean before he'd be released. Thank you.
All right, Mr. Fish, if we test you today, are you going to test clean?
Good. I will. I think. Thank you.
All right, that's all I want to hear.
Okay.
The question before the court is that of bond. Mr. Fish has exercised his right to a hearing. Hold on. Mr. Fish has exercised his right to a hearing in this matter. The court therefore needs to consider bond. Apparently, this is, Mr. Court's attorney, his first bond violation issue. The underlying charge is a concern given that it is a methamphetamine case. It has not been proven, of course. But that certainly concerns the court. It also concerns the court that the defendant is a third offense, or at least charged third offense habitual offender notice. That means he knows the rules. He knows how this system works. He knows what bond means, what it is and what it isn't. He knows it's a two-way street, that in order for him to be out before the trial of this matter or before it's ultimately resolved, he's got to comply with the rules. The rules are simple. Don't use. There's at least some evidence that he used. And that causes the court concern as well. Having said that, it does appear that bond is warranted in this case. I'm going to go ahead and grant bond. I'm going to modify his testing requirements, though, to weekly. I'm not going to require that he test positive in order to get out. It's a good idea, but let's plan on him testing here within the very near future. He'll certainly be within a week, and we'll know whether or not he's using or not. Mr. Fish, want to be really clear to you. If you violate at all in any kind of hot test, you should expect to spend the rest of the period before your trial or resolution of this case in jail. You understand?
I do understand. Yes, sir.
Okay, we'll do the paperwork. Thank you, everyone.
Thank you.
Thank you, Your Honor.
Tiara, I am thinking that I know Mr. Grabowski is here. If we don't have a clerk for Antrim County, then perhaps we should reschedule this.
Okay.
Mr. Grabowski, are you being held on any other matters other than this bench warrant?
No,
All right, so the only thing that you were brought in for was the bench warrant out of Antrim County, is that right?
well, I've got the, I'm here on another case. And
That's what I'm looking at.
Yeah, I'm still here. I got a $50,000 bond here out of Benson County.
All right, well, look, we're going to go ahead and call this matter. I'm going to arraign you on this, and we'll just, Tiara, I think what we'll do is, we'll just have to make an internal office note. So if you would kind of take notes here, and we'll
Okay.
have to prepare it since the Andrew County Clerk isn't there.
Okay.
It won't take much. It'll be pretty straightforward. So, Mr. Grabowski, you have been brought in, it sounds like for a variety of reasons, but the reason you're before me today is the case going back to 2016 that was in front of Judge Power. That's file 16-4820FC. That is a case that you were sentenced for back in 16 or 17, delivery or manufacture less than 50 grams.
Yeah.
You served your sentence on that, but you did not pay your fines and costs. You owe $2,378.50. Do you have any money available today?
There's no fucking way I'm gonna pay $1 of that shit.
All right. Number one, you're in court. You don't have the right to swear. You need to comport your behavior with the expectations of court, or I'll hold you in contempt. Do you understand?
I don't give a fuck.
Okay, we're gonna go ahead and cancel this meeting. The court will consider whether this hearing, the court will consider whether or not to hold Mr. Grabowski in contempt for his clear violation of the court's instructions and common decency here in court. And we'll have a conversation about that going forward. In the meantime, Ms. Keys, we'll go ahead and see if we can get the Antrim County Clerk set up so that we can have her present at the next hearing as well, okay?
Okay.
So we're going to adjourn this particular hearing. Thank you.